Hi, my name is Scott Richter. I'm a senior director in the New York office of RSM's Forensic Investigations and Dispute Advisory Practice. My background's in forensic investigations and commercial disputes with a specialty in post-acquisition disputes and neutral arbitrations. I'm here with Bill O'Neill, who is an accomplished trial lawyer with Winston Strawn and litigates a variety of high-stakes business disputes. Bill frequently represents buyers and sellers in post-closing disputes, including working capital, rep and warranty, and fraud claims, in addition to representing buyers in claims against rep and warranty insurance carriers. Bill, welcome.
Thank you, Scott. Glad to be here.
So, Bill, we should compare and contrast the role of the accounting professional and the legal professional in a post-acquisition dispute. I mean, for me, one of the most important roles as an accounting advocate or a neutral arbiter in a post-acquisition dispute is to not try to practice law. Most purchase agreements we see prescribe GAAP, US GAAP, as the manner in which buyers and sellers should prepare their closing statements. And there could be a whole host of technical accounting literature that applies. So, we help attorneys draft that accounting language and submissions to the arbiter, but we tend to stray from trying to interpret contractual language, or for that matter, being too argumentative in the language that we're trying to draft. Can you talk about how you see your role in a post-acquisition dispute?
Sure. I view our role as very much a partnership with the accounting experts. And I tell all of our clients when we're doing working capital, when we're doing rep and warranty insurance claims, the majority of the time and effort is probably going to come from the accounting experts and a little bit less from me as the lawyer. So it's typically 60-40 or 70-30 on the accountant side when we're talking about working capital and when we're talking about proof of loss or rep and warranty insurance claim. Now, when we talk about Delaware litigation in an indemnity claim or a fraud claim, that flips and it's probably the inverse where it's 70% my time, 30% the accounting experts, but you almost can't do one of these cases. And in fact, the worst outcomes come from whether it's on my side or the other side when a lawyer tries to go these alone, in my view, without accounting support and expertise. So from the very first day of the engagement, I'm pretty aggressive with our clients about the need to bring in forensic accounting expertise because you have to have kind of an integrated team that works well together, and that you have to understand both the accounting issues and the legal issues. And it's the combination of those two disciplines and expertise that really give and lead to the best advice to the client and then therefore the best outcome.
Yeah, I think the most important thing you said was partnership. It really is a true collaboration because, we're trying to bring to bear the best product for the client that we can. And you really can't have one without the other when it comes to these post-acquisition disputes. How do you think that the involvement of dispute professionals such as us has changed recently in post-acquisition disputes?
Well, I think there's more of these disputes. You're seeing a higher incidence of claim rates. So I think the advent of rep and warranty insurance as a product has led, to there to be more claims out there, and there also has been a massive uptick in M&A activity. So 21 was a record year by any measure, whether deal size or aggregate number of transactions closed in the history of U.S. M&A activity. So there are more deals. There's a greater understanding by buyers to be more sophisticated to understand their post-closing remedy options. So you're seeing a little bit more claim activity, therefore a little bit greater engagement of forensic accountants involved, at all stages of the process. But I think there's just probably an enhanced sophistication in the M&A market for how to do these really well. And so, 5 years ago, there was not much rep and warranty insurance. It was a little bit more of a buyer-friendly market. Now, with the transition to a more seller-friendly market, the introduction of more insurance products, the much more capital flowing through the private equity stream, you have serial acquirers and divestors who are very, very sophisticated, who have deep relationships with great accounting firms like RSM and law firms like Winston who know what they're doing in this space. And so you're seeing I think, a more sophisticated evolution of post-closing dispute resolution.
Yeah, and to your point about the activity, we've had our busiest last couple of years in this whole post-acquisition dispute space, and we're starting to get calls. Clients are getting wiser, and they're calling us earlier in the process. It used to be that we'd get a call saying, "Hey, we just signed a engagement letter with a neutral arbiter. Can you help us?" And we're left to sometimes clean up messy accounting issues that we might otherwise would have advised them not to take had they called us either pre-arbitration or even pre-close to help advise them. How successful might you be if this winds up in a dispute? How aggressive are you being? And kind of shepherding them through that process to avoid a costly dispute down the road. To your earlier point on rep and warranty claims, I know activity has ticked up a lot in that in the recent couple of years. What issues that you see primarily that are different in a rep and warranty claim involving the accounting issues that you aren't seeing in a traditional net working capital post-acquisition dispute?
So, Scott, I think the biggest difference you see in the rep and warranty market is the issue of multiplied damages. So, as you know better than I, in a working capital dispute, you're talking about a one-time loss. It has an impact that is non-reoccurring in nature. And when you get into the rep and warranty insurance world, oftentimes the financial statement claims affect the trailing 12-month EBITDA, and upon which the purchase price was based using a multiple. And so I get a lot of phone calls from buyers, asking to talk about whether the multiple is appropriate or not appropriate for that type of claim. And that is, obviously, that's a huge financial driver. As deal markets have gone up, we're seeing multiples, well in excess of 10 on transactions recently. And so obviously that can turn a relatively small, one-time issue into a much larger issue given the multiplied effect. And obviously the rep and warranty insurance carriers are hypersensitive to that. And there are times when the multiple is perfectly justified and appropriate, and there's other times when it's not appropriate due to the nature of the loss or based on, how long the impact of that loss is going to really be felt. I mean, just because the buyer decided to pay 10 or 12 times for that business doesn't mean that impact of, say, that material customer loss or is going to last, 10 or 12 years in the future. So a lot of times I work with you and sort of triangulate around that loss, flushing the loss through the buy side model to see what the impact of that would have been. Sometimes that involves a DCF analysis. Sometimes that involves multiplied damages. And to really put our thinking hat on with you, to think about if you had repriced the transaction on perfect information, what would a hypothetical buyer-seller renegotiation have really led to? Because that is really the question that we're trying to answer and the insurance carriers are trying to answer when we make a claim that sounds in a multiplied loss.
So those can get pretty sophisticated. The issues that are getting sorted out in a rep and warranty claim, there's a lot of drill down associated with those, as opposed to the straight up net working capital issues that you see in a post-act dispute. So it's probably, and I try to advise clients as best I can on this, and I always tell them it's probably unrealistic to make a transaction totally immune to a post-acquisition dispute. But there are some ways that you can help mitigate significant dispute issues arising in a post-closing matter. Do you have any thoughts around that? Some of the things that you might advise clients to include in a purchase agreement, let's say, to avoid those kinds of significant issues?
Absolutely. Two things come to mind. Number one is earnouts. So earnouts are frequent in the buyer and seller can't really agree on an upfront purchase price, and they want to put off some of the sort of deal making into the future to see how the business ultimately performs, because the seller is typically more bullish on the future performance and the buyer might be more skeptical. And so they say, let's agree to defer the last piece of the purchase price consideration to some point in the future. That obviously makes sense from a business perspective at the time, but often that leads to a lot of disputes over those. And there's no issue in M&A litigation litigated more frequently than the earnout. So I would always caution our clients to really think hard and define the parameters if they're committed to an earnout really well. And the second thing that I try to counsel folks on involves the working capital process. And that is, as you know, a typical purchase agreement has a definition of capital A, capital P accounting principles, defined term. And they define, is GAAP going to trump historical practice or vice versa? And there's the nuance that goes in the definition of accounting principles. And I know you spend a lot of time unpacking that nuance. Yeah. And then in addition to that, there's also oftentimes a schedule attached to the purchase agreement that is a sample closing statement. And there's a lot of deals that I pick up where those two, the definition of accounting principles and then the schedule that's attached, don't always mesh perfectly. Right. That's a very obvious place where it can lead to disputes, because obviously you have a buyer and a seller taking different interpretations, and there's usually something both can latch onto, whether it be the accounting principle definition or the schedule, and you have one side arguing one and the other side arguing the other. And it's really created out of ambiguity that in probably imperfect drafting. And I think some of that comes from just like the speed at which transactions are being closed at, right? We're in a hot deal market. We're seeing deals get done in a matter of days and weeks. And when you sort of push the accelerator so aggressively to get to closing, it's really hard to tie the schedules perfectly to the definition of accounting principles. But that issue I've seen lead to a lot of disputes that may have been avoided.
Yeah, and we continually see that when we act as neutral arbiters, and we're more often than not being asked to act as accounting experts, not arbitrators. But we're forced to, make some contract interpretations of the accounting language, where we're being asked to look at the definition of accounting principles, looking at the illustrative net working capital exhibit that purports to sync up with what the parties intended that net working capital calculation to be. And, as you say, each party is arguing their own interpretation of what they think that is. In some cases where we see a party maybe taking advantage of a loophole, we might try to get behind the spirit of what the parties intended. But again, we're accountants. We like things more black and white than gray. And we advise our clients, when we're asked to look at deal language, just say, hey, look, you better make an illustrative calculation of this. You better even, take something from your trial balance so it's crystal clear what accounts you're including and excluding from the calculation, so there's really no doubt. And all that's really left is maybe a subjective gap interpretation at the end of the day.
So you mentioned accounting expert. There's one point I think it'd be helpful for your audience to hear on that. The Delaware case law has recently evolved on. There are a lot of purchase agreements when they choose to resolve working capital where the parties can either choose to designate a firm like RSM or one of your peer firms as an arbitrator to be the decider of the working capital dispute. And there's also Delaware case law has recognized a very distinct designation as accounting expert, meaning you're serving in a very similar capacity, but it is not an arbitration. Right. And those words sound really similar to a lot of people and a lot of clients. But the case law has come out recently that the verdict from the accounting arbitrator or the accounting expert will be handled very differently depending on what words are chosen by the deal lawyers in the agreement. And so I've seen more and more purchase agreements which use the nomenclature accounting expert, that the losing party in that working capital dispute then does not want to recognize the outcome, and then say, well, I essentially get a second bite at the apple in front of the court on that issue, and the courts have been receptive to that. So I think the practitioner's tip for both of our clients is, if you want the working capital process to be final and binding on the parties, then you need to call RSM or whoever you select as your neutral an arbitrator and not an accounting expert. If you want that process to be subject to potential relitigation in the Delaware Court of Chancery, then use the definition accounting expert. So those words really have meaning, and I don't think all of our clients necessarily understand when they choose those words that there's a big difference.
Yeah, and we more often than not in the last 2 or 3 years will not see anything calling us arbitrators. It's most often accounting experts, and they'll even say, the neutral accountant is to act as an accounting expert, not as an arbitrator. They'll come right out and say it. And we're okay with that. We know how to stay in our lane. But that has definitely evolved over time. Okay, well, just to wrap up with some good words of advice for companies that might see themselves heading towards a post-acquisition dispute. One of the things that I always do when I get that first call is ask if they've spoken to counsel about this situation that they have and they're headed towards a dispute, or they've received a notice of objection, or whatever the case may be. My feeling is always to start that partnership we talked about earlier on right away. To me, counsel really adds a lot of value when they can anticipate all the steps that could possibly happen next, all the way to arbitration. I can certainly advise on the accounting issues. I can certainly advise on what may or may not happen through an arbitration process, but I always like counsel to weigh in on tactics and strategy, and knowing your client, where it might be best even to try to negotiate something if their position is weak, try to temper emotions, et cetera, et cetera. So anything that you want to add to that as far as initial stages?
Yeah, I would say get a great team, right? Get a great team in place early, and oftentimes the first phone calls to the lawyers go to the M&A lawyer, and the first phone calls to the accounting firms go to the quality of earnings provider. And it's important to get connected to people who specialize in post-closing disputes at whatever law firm and accounting firm you work with, because it's a little bit different world than the M&A activity sphere, and to get those people involved early, and not only to get the right experts, but also to go through a process that you and I, Scott, sometimes call scorecarding, with really objectively looking at the issues, whether it's an indemnity claim, a working capital claim, or a rep and warranty insurance claim, and to think multiple steps down the chessboard of what the move and counter move is going to be and what the opponent's going to say, and really flesh out, okay, what are our arguments, what are their arguments, and what objectively, if we were sitting as a neutral, how do we feel about this argument, and kind of rate it 1 to 10, so that, and to give that advice to our clients so that they can do the best job of going into a dispute with a fully formed view of what the economic value of that claim is when you consider the cost of the dispute. I mean, there's tons of working capital disputes and other disputes that I see that really should be negotiated out between buyer and seller, but one side just isn't getting great advice from their advisors. And so I just frequently try to counsel people to get great advisors and ask them for objective advice. And so you as business people can go into a dispute making really, really smart decisions and calculated investments in the dispute.
Couldn't agree more. And to your earlier point, the best advice is to get the right professional for the job. Oftentimes I get referred matters through our M&A transaction advisory group, and those guys are fantastic at what they do, but they don't operate in the dispute phase and the dispute space, and they're smart enough to call me because they know I can work in collaboration with them to understand the transaction and then kind of take it from there. Similarly, when I get calls from clients and they might have bounced it off their M&A attorney, I typically will say, well, you may want to have him walk down the hall and poke his head in the litigator's office, particularly someone who has experience in these kinds of matters, and get his or her thoughts on this situation. So great advice. Bill, I can't thank you enough for participating today. And hopefully we've left our current clients and prospective clients with some good food for thought.
Thank you, Scott. I appreciate it.